Good afternoon and good morning to everyone. Welcome. Thank you for joining us for our webinar, How to Avoid an Accidental Franchise, presented by Quarles. My name is Tim Brinkley. I'm a partner in the Quarles Chicago office. My practice focuses on transactional and regulatory matters for franchise companies. I provide day-to-day legal counsel to franchise companies and offer advice to businesses that want to franchise their concept. Today, I'm joined by my colleague, Nick D'Amico, from our Tampa office. So we first have to cover a few logistics items. This is required for compliance. First, unfortunately, our colleague Megan cannot join us today. All comments in today's webinar are off the record and not for publication. All attendees are in listen-only mode, but we welcome your questions via the Q&A box located below the slides in the webinar dashboard. We don't have time to answer all the questions during the webinar. We'll follow up over email. I apologize. Quarles is happy to be able to provide CLE credit in most U.S. jurisdictions for Quarles webinars. As of April 2024, the American Bar Association manages the CLE applications, attendance submission, and certificate of attendance for our external webinars. We have updated procedures for tracking attendance for CLE credit. They include the following. You must be logged in, participating from your own device, and need to actively watch the entire webinar. Please watch for pop-up polls with audio notification that will appear at several random times during the webinar. You must click on the pop-up polls to verify your attendance. Regulators require attendance to be verified, and this procedure meets that requirement. Please take a moment to review the resources box below the video feed, where you'll find a copy of today's presentation, a survey link to share your feedback, and CLE application information. You can access closed captioning during the live webinar by clicking on the CC icon in the lower right-hand corner of the video player. Today's webinar is being recorded. All registrants will receive the on-demand link within a few days. With that, we'll get started, and I'll hand it over to my colleague, Nick, to introduce himself and begin the presentation.
Thanks, Tim. Appreciate that. Like Tim mentioned, my name's Nick D'Amico. I'm an associate in our Tampa office. I'm in our business law group, and my practice primarily focuses on franchise, transactional, regulatory, and compliance matters, very similar to Tim. Not much more interesting about me, so I'll just jump into the presentation. Today, we're covering how to avoid a franchise, an accidental franchise. So the roadmap for what we're going to be discussing too. First, we're going to give you a little introduction on what a franchise is and how it's the substance really of the relationship over the form. We'll give you an overview of how these franchises are regulated and why that matters to the audience here is because we're trying to avoid that. We don't want those regulations to apply to us. They're onerous, they're time consuming, they're expensive, and they're frankly kind of tough to comply with. I like to think Tim and I are pretty swell guys, but to the extent you can avoid working with us as much as possible on this kind of stuff, I think that's the goal of this presentation. Typical types of accidental franchises and consequences and potential solutions. We're going to cover, what these things look like practically and what to do if you find yourself in a situation where you did sell what you thought was, say, a distributorship, and it turns out it's a franchise and it's going to be regulated under federal or state law as such. Okay. So the quick intro here, substance over form. So franchise laws will apply regardless of the terminology that's used. You'll hear all kinds of other common terminology for franchises, things like it's a distribution agreement or a distributorship. It's a license agreement, a marketing agreement. You often hear things like it's a joint venture or some kind of partnership. All of these arrangements, if they meet the test for the definition of what a franchise is, then the laws that regulate franchises will apply, even if we called it a license, even if we called it a joint venture and used an operating agreement, that kind of thing. If it meets the elements that qualify as a franchise, then that's what's going to apply. The second point is that the franchise can exist even if both parties did not intend it to. If there's some kind of language in an agreement that says the parties agree and acknowledge that this agreement does not constitute a franchise relationship, doesn't matter. These laws are really fundamentally, they're a consumer protection law. There's a perceived abuse where it's one of two ends of a spectrum. There's the really, really large franchisor. And the perceived abuse here is that the large franchisor has all kinds of bargaining power and can force bad terms on franchisees. And so the laws try to account for that. And they'll say, no, this or that type of term, liquidated damages or choice of law or venue, those kinds of things are not going to be enforceable if this is a franchise, because we think that there wasn't equal bargaining power here. And the other abuse that regulators seek to avoid is the other end of the spectrum. Rather than the large franchisor, it's the really, really small franchisor, the fly-by-night. This is someone who came up with a concept, right? They might have a brand, they might have a little logo or something like that, and maybe a pretty quick and dirty business plan. And they sell, quote, franchises for $50,000 initial franchise fee, and then they move on to the next state. You never hear from again, and it's really just a fraud issue. And so, what the regulators try to prevent there, again, they'll regulate that relationship in an effort to protect consumers from that kind of abuse. So for that reason, we can't simply say the parties agree that this isn't a franchise, because ultimately we're trying to protect prospective franchisees from those abuses. And finally, just a high-level note: this isn't just one law. It'd be wonderful if it were, but we live in the United States, and we always have this federal-state overlay. I'm sure anyone who practices in other areas is familiar with this kind of thing. There's a federal law that regulates franchising, and several state laws that in a patchwork way regulate all different kinds of franchising. It's not just regulating disclosure, requiring certain disclosure. There's regulation of the relationship, regulation of the disclosure of franchises, requirement to register your franchise offering. We're going to get into that today. But just to note that it's complex, federal and state. So you got to know where you are as a prospective or putative franchisor, and where your prospective franchisees are, or in this case, hopefully not franchisees. So with that, we'll dive into this web of laws. The first and probably most important point is what is a franchise, right? We're trying to avoid that. So what is it? Under federal law, the definition involves three, sort of four elements, but really three. So it's a continuing business relationship. You can think of that as the first element, this continuing relationship that features these three things: the use of a trademark, the control or assistance from the licensor or franchisor, and some initial or ongoing payments from the licensee to the licensor. So for the first element on a trademark, virtually any relationship in which the franchisee benefits from the franchisor's reputation is going to satisfy that element. So to avoid application of the federal law, the use of the mark by this licensee must be expressly prohibited. You have to say the franchisee is not allowed to use it at all. Can't be limited in a certain geographic area or anything like that. If they're allowed to use the mark, you're probably going to satisfy this element. The second element, control. The language in the FTC rule is the exercise of significant control over, or the giving of significant assistance to, the franchisee's method of operation. So significant relates to the degree that the franchisee is dependent on the franchisor's business acumen. I mean, that's why they're buying the franchise. They could have gone into business on their own, but they figured, I want to affiliate with the system who's done it before. They have a proven method, and I want to buy into that. So that's this element. Are they buying this assistance or control from the franchisor? And it must relate to the entire method of operation, not just a specific product or service. So, if you're a milk producer and you're selling milk to distributors, well, of course they have to keep it refrigerated, and you can require that as a producer. You need to keep the milk at X temperature, right? That's not control in this sense. It needs to be control over the entire operation of the business. Examples of this are the site design or appearance requirements, the signage they have to have out front of their shop. Hours of operation, you got to be open on weekends if it's a restaurant or bar or something like that. Production techniques, this is the sort of the secret sauce kind of thing. Accounting practices, personnel policies and practices, wearing your classic uniforms that everyone associates with this or that particular system. Required franchisee participation in promotional campaigns or financial contributions. This is contributing some kind of money to an ad fund. That's going to satisfy assistance or control. Customer restrictions, who you can sell to, right? Or location or sales area restrictions like territories. Control does not include things like measures solely to protect the trademark owner's rights. So if we say, you can't take my mark and modify it, I'm not really controlling the way you operate your business if I say that. I'm just protecting my interest in a trademark. That's perfectly legitimate intellectual property protection. That does not constitute control that's going to satisfy this element for the definition of a franchise. Health or safety regulations, right? If you say that you have to keep your business clean to satisfy requirements under applicable law dealing with sanitation, that's not going to satisfy the control element. That's pretty standard across the board for any business. Credit card and credit card service arrangements and assisting distributors in obtaining financing. Again, these are not going to satisfy the control element. We see that in this definition that is control or assistance. Assistance is thought of as a slightly different concept. This is assistance from the franchisor to the franchisee. This is the operations manual and things like that. And notably, this applies even if the franchisor doesn't actually provide the assistance, right? So you don't get out of it just by being a bad franchisor. If you intend to provide the assistance, or you agree to provide it, it's in the franchise agreement that you have to provide it, it's going to be considered, or at least it will satisfy this element of the definition of a franchise. This includes things like conducting formal sales, repair, or business training programs, establishing accounting systems, furnishing management, marketing, or personnel advice, selecting a business location, providing an operating manual. That's a big one. Basically, every franchise system has one, and so that's going to be an obvious one that satisfies that element, or furnishing system-wide networks and websites. And then finally, the fee element, initial or ongoing payments. It has to be a fee from the franchisee to the franchisor or any affiliate of the franchisor of at least $615 at any time during the first 6 months of operation. So basically anything will satisfy this. This isn't just paying a fee or royalties. It includes things like if the franchisor owns the real estate and leases the real estate to the franchisee, that's going to count for the fee. If the franchisor licenses software to the franchisee, that's going to count as the fee. Payments made that are practical necessity for equipment, that the franchisee has to buy a certain kind of equipment. Even if we say you can get it elsewhere, but if as a practical necessity, the franchisor is really the only one that you can get this from because it's put together in such a way that it would be impractical for the franchisee to go elsewhere, payments for that equipment are going to count as the fee. There is an exception, and I think we'll talk about this one later, that any payment for reasonable amounts of inventory at a bona fide wholesale price will not satisfy the fee. And the reason being, this exclusion is intended to capture things like distribution arrangements. So if you have a distributorship and you're buying products at wholesale to then sell at retail, that's not going to be paying a fee. So that allows those kinds of legitimate retail operations that are not franchises to not be captured by this rule. But again, it has to be a bona fide wholesale price. It can't be a markup because it's the special franchise product that only the franchisor can purchase. And one note on these three elements, they need to all be satisfied. So we're talking here that this presentation is about avoiding accidental franchises. So what we're going to talk about, what Tim's going to be discussing later, is how do we knock out one of these three? How do we avoid using the trademark? How do we avoid providing control or assistance? How do we avoid a fee? What are the kinds of things we can do to still collect money, but it won't be construed as a fee or a payment? So if you can knock out any one of them, then the relationship, at least under federal law, will not be construed as a franchise. Okay, under state law, they're essentially the same, although there's a slight difference with the control or assistance. So the use of a trademark and a fee are generally still contemplated under the various state laws. But then there's this third element that's a little bit different, and it depends on what state you're in. And this is what I was talking about earlier with this sort of patchwork of state regulations. In certain states, there's what's referred to as a marketing plan. For example, in Washington, they use this marketing plan approach. That is, the franchisee is granted the right to engage in the business of offering, selling, or distributing goods or services under a marketing plan substantially prescribed by the franchisor. This generally means a plan or system concerning an aspect of conducting the business, and it includes any one of these following things: price specifications, like special pricing or discount plans, sales or display equipment. This is signage, things like that, merchandising devices, sales techniques, right? Different kinds of advertising methods and things like that. Promotional or advertising materials or cooperative advertising. So this is if the franchisor provides advertising collateral. That's going to be considered a marketing plan under this state law test. Training regarding promotion, operation, or management of the business, and that's another one that most franchise systems provide some kind of training. And finally, operational, managerial, technical, or financial guidelines or assistance are going to satisfy this marketing plan element. The other element in different states, together with the trademark and payments, is this community of interest. Minnesota uses the community of interest test. The franchisor and franchisee have a community of interest in the marketing of goods or services. Not precisely defined in the Minnesota statute, of course, but this is generally understood to mean that the parties have a common continuing financial interest in the operation of the business. In other words, the franchisee selling products is good for both the franchisee and the franchisor. They have a community of interest. Their interests are in common in that sense. So bottom line, under federal and state law, you essentially have three elements. There's the use of a trademark, a substantial association with the trademark. You have some kind of control or assistance from the franchisor, or in the case of state law, it would be this marketing plan or community of interest. And finally, you have some kind of fee. Those are the three elements. If you satisfy those elements, it's going to be a franchise unless we can have some kind of exemption or exclusion. We'll talk about those exemptions and exclusions later. Okay, so how are franchises regulated? This is what we're trying to avoid. We don't want this to apply to us because, like I said, it's expensive, it's onerous, time consuming. And if we're not in the business of selling franchises, we don't want to have to deal with this. Okay, the federal law is the law that was promulgated by the FTC, the Federal Trade Commission. It's a disclosure law only. There's no requirement to file with the FTC. You just have to prepare this disclosure document. And it only regulates sales. So it doesn't regulate offers. You can have discussions with franchisees. You just can't close the deal. You can't sign a franchise agreement or collect any money from the franchisee until you've complied with these disclosure obligations. Generally, the FTD, the franchise disclosure document, this is what's required by the FTC, generally includes 23 items that answer we kind of break it down to about these 4 questions. You can slice and dice the FTD in all kinds of ways, and actually the FTC has been talking about finding different ways to streamline it or reorganize it. Here's one way we think of it. It answers the question, who is the franchisor, right? Who am I dealing with? Who are their managers? What kind of litigation are they involved in? How many units are in this system, right? Who am I dealing with? The next question, how much will it cost me as the franchisee to buy into this system? This is both how much in fees do I have to pay the franchisor, and how much will it cost me to get started, right? My initial investment. I have to buy equipment. I have to outfit a office or a retail establishment or a gym or something like that. Third, how much will I make? Item 19 of the FDD provides what's called a financial performance representation. This is, average sales or revenues. There's all kinds of different ways you can present this data, but generally it's some disclosure of revenues that that actual franchisees have earned, or a projection as to how much they could earn. Finally, what are the terms? This is, the terms of the franchise agreement. They're broken down in different ways in the FDD. That's what the disclosure document is intended to do. Just provide information to the franchisee. Again, it's a long document. Usually it's 200 pages or more. I've seen them nearly 1,000 pages. So again, we don't want to have to prepare one of these if what we're trying to do is not a franchise. You're required. The disclosure document must be provided to the prospective franchisee 14 days in advance of signing. The purpose of this rule is to prevent, high pressure sales tactics. Again, as I mentioned earlier, this whole legal regime is really a consumer protection. And so again, this is another one there is a perceived abuse of, sign now, we'll give you this big discount. This is the best opportunity ever. So they want this sort of cooling off period. There's a requirement to update these disclosures at least annually. The way it could be more than annually is if there's what's considered a material change to the franchise offering. Whether it's material, we tend to say just be conservative. The test is similar to in securities law. That is, would it change the prospective franchisee's mind as to whether to invest? Would a reasonable person with this information say, you know what, no, I actually don't want to buy this franchise because I understand now that you're involved in this litigation and that, I don't want to have to deal with that. Finally, a point in the FTC rule, there's no private right of action. So if we don't comply with this law, the FTC could bring a compliance action against us. But the franchisee can't sue us under the FTC rule. But virtually all states have what's called a Little FTC Act, or kind of colloquially referred to as a Little FTC Act, which does give a private right of action to aggrieved franchisees if the law wasn't complied with. And it can range from anything from fines to kind of the granddaddy of remedies for franchisees, and that is rescission. They can terminate the franchise agreement and get their money back, plus other kinds of damages and things like that. So it's important to comply with the FTC rule. And if we're trying to not be a franchise, we really want to make sure we're not, because if we don't comply with the FTC rule, a franchisee could have a claim under one of these Little FTC Acts and get out of their franchise agreement and then require us to basically pay for all their losses. Okay. State laws also regulate franchising in addition to the federal law. State laws regulate basically in three ways. First, we'll talk here about franchise registration. The registration states are California, Hawaii, Illinois, Indiana, Maryland, Michigan, Minnesota, New York, North Dakota, Rhode Island, South Dakota, Virginia, Washington, and Wisconsin. They have varying jurisdictional tests, whether the franchisor is based there, whether the prospective franchisee is based there, physically domiciled there, or whether they're going to operate the business there. These registration laws can apply. The registration process can be kind of onerous. We have to file that FDD. So the FDD that you prepare under federal law, you have to file it with the state. You have to prepare all kinds of application materials. And then typically in many of these states, not in all of them, but in many of them, the state will review the document line by line. And they'll provide you comments and questions, and they won't approve the registration until you've responded and satisfied all their requests. Typically, this will take anywhere from 8 to 12 weeks. And the most important point here is you can't sell in the state or even offer in the state unless registered. Before I mentioned under the federal law that it regulates only sales. Under the state laws, it also regulates offers. So you often hear franchisors referring to being dark in this state. They can't even talk. You can't even talk to a prospective franchisee. Yeah, and that's a conservative approach. But certain things that you say could be construed as an offer, and that could violate those state registration laws. And there are private right of actions in addition to enforcement actions and all kinds of fines. We've seen fines in 6 figures from clients who came to us. They said, "Oh, we got this letter from the state. We didn't even realize what we were doing. That we were selling franchises in the state. We thought it was a license." And you sell 20, 30 of them, and each one is a violation of both the registration and the disclosure law under the state, and it starts to add up. So it's important if we're going to sell things like licenses and distributorships to make sure that we're in one of these states, to make sure that we're either complying with the registration law or we're satisfied that we're exempt or excluded from it. Went back there, okay. There are other filing requirements and other laws as well. The ones I mentioned earlier were the registration states we classically consider to be the full Monty registrations where they provide common letters. There are other states as well that require this. So this first set, Connecticut, North Carolina, South Carolina, and Maine, they have registration laws as well, but most franchisors don't have to comply with it because most franchisors have a federally registered trademark. But if you don't, then you also have to register in those states as well. And then there's franchise filing states or business opportunity filing states. These are Connecticut, Florida, Kentucky, Nebraska, North Carolina, South Dakota, Texas, and Utah. You see them listed here. These are states where it's not that you have to file the full FDD, but these states may have what's called a business opportunity law, which is a broader body of law that applies to things that often includes franchises, but it also includes things like multi-level marketing arrangements or operate a vending machine or envelope stuffing campaign, that kind of thing. these businesses are considered business opportunities. The definition of business opportunities is often broad and expansive and includes franchises. But as long as you satisfy the federal law or you have a registered trademark, those kinds of things, you'll often be exempt from those business opportunity laws. And that's what these filing requirements are. In these states, you're saying, yeah, no, we comply with the FTC rule. This is a franchise. It's not really a business opportunity. You make a filing, much simpler, but again, something to make sure we're aware of if we're selling, a distributorship or something like that in one of these states. Okay. So this is another important one. I mentioned that the definition of a franchise is important because if we can avoid the definition, we're not considered a franchise, and that's what we're trying to do. Here's another one. If let's say we are a franchise, we can be exempt or otherwise excluded from the law. The exemptions under federal law exempt you from the disclosure obligations. Like I said earlier, the federal law is only a disclosure law to begin with, and so of course, if you're exempt from it, you don't have the disclosure obligation. The exemptions under state law, again, it's a patchwork. They vary. Remember, the state laws they require registration, but they often do also require disclosure. And so the exemptions might, depending on what exemption you're qualifying for, it might exempt you from the registration requirement, but not the disclosure requirement. It might exempt you from disclosure and not registration, or it might exempt you from both. Typically, no matter what it exempts you from, you still have to comply with any anti-fraud provisions. You can't lie or materially omit some fact. So they won't exempt you from those unless there's an exclusion. Now, it's maybe somewhat technical, but it does matter. The difference between an exemption and an exclusion. An exemption from one of these laws is that what I'm offering to prospects would be considered a franchise. In other words, it meets those three elements. There's a fee, there's a trademark, and there's a marketing plan or a community of interest. So it meets those elements of a franchise. But nonetheless, the statute or rule is saying, based on some criteria like net worth or something like that, we think that this offering can be exempt from the law. An exclusion, on the other hand, is saying that the offering doesn't even meet the definition of a franchise at the outset. This is what Tim's going to be going into with some examples, but we've knocked out the trademark element. We've knocked out the fee element. We're excluded from the law entirely. That's the holy grail here. If we can be excluded from the franchise law, that's what we're shooting for. Exemptions will work too. It's always important to look at the statute when you're trying to comply. Exemption-based franchising is technical and challenging. And so it's important to review the statute to make sure that the exemption actually applies. There are often filing requirements. Sometimes the filing has to be before, sometimes after, but that's the idea. Okay, so here's a quick primer on what some of these federal exemptions are. I mentioned earlier that the fee element is that any collection of fees that is in excess of $615 in the first 6 months. So if you're less than that, then you're exempt. It's because you haven't, and actually that's technically an exclusion because you aren't meeting the fee element. And you can use a promissory note. So you can say we're going to defer fees until after 6 months. That would work to be excluded from the franchise law. A fractional franchise. Think of this as like a add-on to an existing business. You'll see this in medical franchises. You'll often see this kind of thing where they can add on a piece of their practice to an existing medical practice. They need to have been operating their existing business for at least 2 years. And the add-on business or the fractional franchise needs to be less than 20% of the total revenue of their full business enterprise. And notably, you don't need to actually prove that after the fact. You need to have a reasonable basis for believing that before the sale's made. A lease department. This is something like a Sephora and a Macy's. This is where there's an arrangement where the retailer licenses or otherwise permits a seller to conduct a business within the retailer's location. Where the seller purchases no goods or services or commodities directly from the retailer. Okay. Gas station franchises, these are excluded or exempt only because they're just covered by a different federal law. So that one doesn't really, help you too much. You got to comply with the Petroleum Marketing Practices Act. The next one is a high initial investment. If the initial investment is at least $1.233 million. And again, I mentioned earlier, right, this is a consumer protection law. That's kind of what they're getting at. There are perceived abuses by franchisors having, making mom and pops empty out their savings to buy the franchise. So the idea is, if someone can afford, this amount, the FTC rule thinks, or the FTC believes that that person is sophisticated enough to be able to analyze this business opportunity and not get, defrauded by an unscrupulous franchisor. The next one is a similar theory. The sophisticated franchisee, 5 years of business experience, a net worth of $6 million and change. A similar idea here. They're presumed to have enough experience that the law doesn't need to apply to them. And finally, a renewal. This one's actually exempt. It's not considered a sale. If you renew a franchise agreement for another 10-year term or something like that, the franchise law will not apply to that renewal. Now, notably, the agreement has to be the same or substantially the same. Most of the time, franchisors will require the franchisee to sign a new franchise agreement upon renewal. If you do that, the renewal, you then have to provide disclosure and satisfy the other requirements of this law. It's only if you're simply extending the term of your existing arrangement another 10 years, that won't count as a sale of a franchise. Okay. So again, these are exemptions under the federal law. These are things that will exempt you or exclude you from the federal law so that you don't have to provide disclosure. Now, if you're in one of those states I mentioned earlier, you'd still want to make sure you're exempt there. Now, the state exemptions, of course, it's a patchwork. That's kind of the theme here. They're tough. They vary both in character and degree. So in other words, there are different kinds of these exemptions. And even where they're similar, like the net worth of a franchisee or something like that, the numbers are always a little bit different. So you got to read each one. And they may or may not overlap with the federal law. For example, the federal law does not have a large franchisor exemption. Okay, so here's the example here that we give to show this patchwork. In California, there's a large franchisee exemption. It applies to either, and all of these are kind of either or, an entity with $5 million in net worth, an individual with $1 million in net worth, or an individual with $300,000 in income, or $500,000 together with his or her spouse. You're required to make a filing in order for this exemption to apply, and you would be exempt from the full registration requirement in California and certain disclosure obligations, but otherwise you'd still have to provide disclosure. Compare that to the large franchisee exemption in Washington. Same $5 million requirement for an entity, same $1 million requirement for an individual, but a slightly different income requirement. And then in Washington, there's no filing requirement, whereas in California, there was a requirement to make a filing. And then in Washington, you're exempt from registration and disclosure entirely, whereas in California, there were still some lingering disclosure obligations, largely would be satisfied if you comply with the FTC rule, but just to note, in Washington, you don't have to worry about disclosure at all. In California, you do under this exemption. Okay. Another example here is on the large franchisor. This is the other end of the spectrum. The franchisor is large. In Illinois, if the franchisor has a net worth of over 10 million and at least 25 franchisees, and it has to make a filing, so that's one kind of exemption you can qualify for in Illinois. Or if you're worth 15 million, then there's no number of franchisee requirement and no filing requirement. And in either case, you're exempt only from registration, but not disclosure. That's Illinois. In New York, you're possibly exempt if you're worth 5 million, but it's at the discretion of the state. You have to apply and write a letter and argue why you should be exempt, and they may or may not grant it. Or if your net worth is worth 15 million or more, it's not discretionary, it's automatic, and there's no filing requirement. Again, this is exempt from registration only and not disclosure. So you can see how there's a bit of a patchwork here that you have to navigate if you're trying to use exemptions to avoid franchise being considered a franchise. And note that, like I mentioned earlier, this exemption doesn't even exist under federal law. So if you're a large, sophisticated franchise or a big system that's been around for a while, you still have to provide the FDD under federal law. You just don't have to register that FDD in these states. Okay. The last sort of pillar of how franchises are regulated are what's called franchise relationship laws. Again, remember, this is a consumer protection idea here. The perception by the regulators is franchisors have more bargaining power. And so we don't want these, we grant a franchise, a franchisee puts a bunch of money into the business, and then the franchisor terminates. right? It says, sorry, take it away from you. You lose all your money, you lose your investment, and you can't compete with me for 2 years or whatever it is. So the regulators are very concerned about that set of facts. And so they have these, you'll see in various states, there are 19 states that impose these relationship laws. They'll say that if you're going to terminate, you have to provide 30 days notice or 60 days notice. You have to give an opportunity to cure. Same with non-renewal. If we're not going to let you renew the agreement, we have to give you notice, and then there has to be good cause, right? You have to have actually breached the agreement. There may be repurchase obligations where if we sold you branded merchandise, we may have to buy it back from you. There may be restrictions on the choice of law or restrictions on non-waiver of law. In other words, you can't agree to waive a relationship law. It just applies whether you have waived it or not. Liquidated damages might be restricted. You may not be able to enforce them. Non-competition agreements might be limited. And there may be restrictions on the franchisor's ability to encroach within the franchisee's territory, even through alternative channels like selling online or things like that, like other direct-to-consumer methods. Okay. And that is all I have on the background of what a franchise is and how they're regulated. So I'll turn it over to Tim for some examples on how you might trip these laws up and what you can do if you do so.
Okay, thanks, Nick. I see we have a few questions that will come in. We'll get to those at the end. Right now, I'll push through some of these typical types of accidental franchises that we see, and you will see a lot of the stuff that Nick covered come back up. So, he covered a lot of territory and what a franchise is, but you'll see it come back up in all these different examples, because as Nick said, what we're trying to do is knock out one of those elements in each case. And also, when you look at some of these too, you can kind of see a little bit of the reason for the philosophical grounding of franchise law and why it evolved over the years. We'll cover these four: trademark license agreements, product distribution agreements, training agreements, and joint ventures. And I'll start in with trademark license agreements, which are perhaps the most common thing that you see, or it comes up when people start thinking about a franchise. So with the trademark license, the first element that Nick mentioned, trademark, well, that almost always exists. So it's kind of hard to knock out that element when you're licensing a trademark. So that one pretty much exists. And also the fee and payments element probably exists as well, because if you're going to license your trademark, you want something in exchange for that. So the element that you need to knock out under federal law clearly is the controller assistance element. So you want to knock that out. You want to make sure that that doesn't exist. And Nick covered some of this, so it'll be a little repetitive. But when you're dealing with a trademark license and you don't want to make sure you creep into a franchise, what you want to avoid are these items that are at the top of the slide here. You want to avoid things like, well, if you want to use my trademark, I need to sign off on where exactly you can use it. I need to know where you're going to operate your business, and I need to approve that, or your entire area where you can operate your business. Or I need to not only to control how the trademark is displayed, I need to control or have approval rights on how your business appears completely. That's when you're getting into too much control. Hours of operation. You must operate during these hours. You must use this accounting system. You can only sell to these types of customers. Again, you're getting in too much control of the business here, and you risk meeting the control element. And then in terms of assistance, a formal training program, something where you have the licensee in to tell them how to sell under your trademark. You give them management advice, or as Nick mentioned, the ops manual, that's the most traditional thing, and certainly all of our franchise clients have ops manuals that we see. And Nick covered some of this as well, but when you're drafting a trademark license, if you want to avoid the control or assistance element, focus on these things. Just controls on display of the trademark. Those are okay, and those are not going to make you run into or satisfy the control element. and Nick mentioned as well, health or safety restrictions that are required by law. It's fine to require compliance with those. And you can even provide assistance in obtaining financing to licensees. So those are just some of the ways that you can seek to knock out the controller assistance element in a trademark license. Okay, so moving on to product distribution agreements. This is obviously when a manufacturer makes a product and wants to distribute it and wants to use distributors that are, in a region or throughout the country to distribute the goods that they manufacture. And Nick covered this very well, but it's what you have to think about. And he mentioned it's called the bona fide wholesale pricing exclusion. And what I've kind of laid it out here, similar to how I did with the trademark license. If you've got required payments that go beyond that bona fide wholesale price, then you might have a franchise on your hands. So things like an unreasonable starting or ongoing inventory requirement, something more than you actually need to run your business. Sales quotas, where you have to sell a certain amount of the products that I'm manufacturing if you want to continue to have access to them. And then when you get into other parts of the business, it's no longer about the manufacturer's product that you're selling. It's about how they're running their business. Okay, so you've got to buy these other items, perhaps from me, perhaps from somebody I designate to run your business. And so if you want access to my goods, you've got to buy this equipment or these supplies from these third parties that I designate. And then training fees, marketing expenses, those types of things. But if you get into those, you're collecting money that's not just for the wholesale price of the goods that you're manufacturing. And so if you can avoid that required payment, then you can stay out of satisfying the criteria for a franchise. Again, it's reasonable amounts of inventory at bona fide wholesale prices. And specifically reasonable amounts, and courts differ on this, but the best we can give you is reasonable amounts mean not in excess of those that a reasonable business person normally would purchase for a starting inventory or supply or maintain on an ongoing inventory or supply. And we should mention the inventory exemption also includes goods intended to be furnished to the public through a lease. So that covers product distribution agreements. Now we'll move on. This is an unusual one, training agreements, and this one can come up when, especially in sometimes even in small towns, a family business of some kind, where they have a successful business and someone from another town perhaps sees it and says, "Wow, I could do that. I think I could do that." And that way, I'm rather than finding a job, I'll just make a job for myself. I'll start this business. And as Nick mentioned many times, the franchise laws, what they're looking to protect are vulnerable people who want to start a business, who earnestly want to start a business, and they are willing to risk, their life savings on starting this business and then being taken advantage of along the way. So even a training agreement runs the risk of getting into this territory. So these are often single unit small businesses on both sides often, but typically the trainer is the more experienced one, the one who has an existing business, who has something they can share with the trainee, and they offer to sell to them. Basically, they're going to sell their know-how and say, "Oh, well, over here in my town, I've got this restaurant business, I've got this plumbing business, I've got something else. I can teach you how to do it. You can do it over in your town, so you're not encroaching on my customers, And you just pay me, and I'll teach you how to run the business, and that's it. That's all you'll need to know. With the theory being that, well, I'll just kind of, show you the tricks of the trade, and then you'll run off and you'll do your business. So the problem you get into here is you can sometimes satisfy the payments requirement through a training fee. Sometimes that can be similar, very similar to the initial franchise fee that you see in the franchise system. And the training itself can meet the assistance element of a franchise. So you have to be careful. And as Nick mentioned also, even the trademark element, if in this case a trainer has any kind of a business or know-how, you even run the risk of satisfying the trademark element because the business system is part of what they're training them on. So like I said, the typical intent is, you're just going to mentor this trainee and then you're going to part ways. But then sometimes it becomes ongoing assistance. And since, the trainee's already paid me for the initial assistance, tell you what, why don't we just agree, I'll charge X amount and I'll provide some ongoing assistance to you. Well, that's where you get into more of a franchise system because you're providing ongoing assistance. You run the risk of meeting the assistance criteria. And it, just like I said, the trainers are often in a superior position. They've already got a successful business. The trainees are new, and they don't have a lot of money, and sometimes they're investing everything they have to start this new business, and they're relying on you, the trainer, to give them the benefit of your experience. And sometimes unintentionally, trainers can find themselves creating a franchise where they didn't intend to. Okay, and then the final type of accidental franchise that we'll cover, that we typically see, is a joint venture. And this one's interesting. It comes up a lot because the business owner, and sometimes their lawyer, honestly, if they have a lawyer that hasn't been exposed to franchise law or isn't terribly familiar with it, but the lawyer may be familiar with a joint venture. And in particular, a lot of the reason franchising exists is because somebody had a successful business and now they want to grow it, but they don't want to spend a lot of their own money, but they want to enjoy the upside from their brand expanding. So you often see this, as I put here, you see this with a successful family restaurant. Some restaurants have been successful for 20 or 30 years in a particular community, and it's done really well, but they've got a larger family, they got more mouths to feed, they just want to grow their business without investing just their own money or without investing too much of their own money. So they go out and say, oh, well, that's fine. We'll do a joint venture. I'll look for somebody who's willing to invest some money and put in some sweat equity, and we'll have a joint venture. And under this joint venture, another location under this restaurant, under the name of the restaurant will be open, and we'll have this joint venture. So, in particular, where not the original business person, the owner of the successful business, but the new investor, the new operator who they brought in, has a majority interest in the joint venture, that's where you run the risk of creating a franchise in particular. Because then the majority owner of the joint venture is the putative franchisee. And you may have met through the joint venture, you may have met all the elements, trademark, payments, and then controller assistance. Because under the joint venture agreement, you can easily envision all of those elements being met. Now, in a situation where you've got the restaurant owner, with the example of the family restaurant, where the restaurant owner has a majority interest, that actually you run the risk, more the risk of creating a security and running afoul of the securities laws than you do franchise laws. But that's a separate consideration. And again, depending on the knowledge of the lawyer that the restaurant founder used or asked for assistance, they may be more or less familiar with securities laws as opposed to franchise laws. So this is just something you have to watch out for in the joint venture context. Okay, and real quickly, I'll cover just some of the consequences and potential solutions, and then we'll try to get to some of the questions that are coming in now. So consequences, and Nick covered some of these. Private rights of action. So there is, under the federal law, the FTC franchise rule, there is no private right of action that exists. But as Nick also mentioned, many states have what are commonly referred to as little FTC acts, and sometimes the federal franchise regulations can serve as a basis for the violation of a little FTC act in the state. And then, of course, there are state franchise laws, which Nick covered in great detail, that can be implemented as well, and a person can have a private right of action under a state franchise law. So government enforcement, it's very, very rare. The FTC does have enforcement authority, and they have historically taken some enforcement actions, but it's very rare. It's very rare you see the FTC get involved in franchise enforcement, but they certainly talk about it when we hear them, and they remind us often that they do have that authority and that they'll use it if they need to. Where you see it much more commonly is in the states, and that's what Nick and I and our litigation colleagues have dealt with more commonly, is when a state sees that someone, again, a perhaps vulnerable person, has been, they think, taken advantage of by someone who's more sophisticated. They'll come in and they'll say, they'll look to see whether or not a putative franchisor has violated the franchise laws of the state. And then they'll usually seek to enforce their law in some way. It could be through some kind of a regulatory action, and the remedies they could seek could be are typically going to be a fine, some type of remedial payment to the putative franchisee, and some kind of training. And then they also want to bring you into compliance with the franchise law of their state. So those are typically what you see from state governments. So potential solutions with putative franchisees and with government regulators. So with putative franchisees, and I should mention one of the questions that's already come in was how do you undo an accidental franchise? And so kind of we can cover that question here on this topic. One of the most common ways that we do it, and Nick and I actually do this in our practice all the time with our existing franchisor clients, is anytime a franchisee asks for some kind of a concession or some kind of a break, things are a bit rough right now, if something happened where I'm operating, one of the major employers left or something else happened, can you defer my royalty payments for a few months? Can you waive some of my royalty payments? Because I think once I get over this hump, the business is still going to be viable. I just need this little help. So what we do is we say, okay, so we'll draft an agreement then, which for existing franchise clients for us, that's usually an amendment to a franchise agreement. What we put in that all the time is we get a release. We get a general release. So we have a release of any claims that may have come from the franchise sale or anything else with a franchise relationship. Because as Nick mentioned, there are franchise sales laws. There's also franchise relationship laws. So we get that release. That's nice because we're kind of starting with a clean slate with this franchisee. Similarly, when you've got the accidental franchise context, so if you have a putative franchisee who is upset, something's happened, they've come on bad times, what you can do is offer some kind of a concession, offer some kind of a break, some discounted or free product, or some time, a waiver, deferral of license fees, or a waiver of license fees, and then you get a release. And with that release, you can address your liability. And I covered some of it with government regulators, but a lot of that is just the government regulators are looking for you to comply with the law generally. Typically, what you want to do is just work with an experienced lawyer who has worked with that state regulatory entity before, and they'll help you work through trying to come into compliance with the law and to address the particular issues they've identified with the putative franchisee in their state. Okay, so we've got a few other questions. We've got 4 minutes left, I see. So we will try to cover these as best we can. Nick, we had one question on what is a franchise specifically in California. Can you cover that one?
Yeah, sure. So California is one of the marketing plan states. So I have the statute pulled up here. Franchise, it's an ongoing arrangement in California where the franchisee is granted the right to engage in the business of offering, selling, or distributing goods or services under a marketing plan or system prescribed in substantial part by the franchisor, and where the operation of the business is pursuant to a plan or system substantially associated with the mark. So there's the marketing plan or system, the trademark, and then the third element is the franchisee is required to pay directly or indirectly a franchise fee. So it's those three elements, and in this case in California, it was the marketing plan, not the continuity of or the community of interest test. So.
And Nick, since you already covered this in your presentation too, can you give an example of a sophisticated franchisee?
Sure. Yeah. The franchisee has to meet those thresholds for net worth or income. So it varies state by state. Speaking more broadly, what they typically look like, if that's what you're getting at with the question, and I think I saw that one too. The idea is, typically these are institutional operators. You'll often see that. I mean, sometimes it's just large, high net worth individuals who are later in their career and they want to, diversify or invest or buy a franchise. But oftentimes you'll see it as it's like an institutional franchise. These are those businesses that operate in airports, for example, or at stadiums, and they run those kind of deals. Those are often exempt because those institutions are worth more than $5 million. And so when you sell the franchise to one of those to operate your restaurant or something at the stadium or at the airport, that's going to be exempt because the franchisee buying that franchise is worth, meets the threshold under whichever state law it is you're trying to qualify for, or under federal law.
Okay, and I'll cover. There's one here. Discuss how real estate becomes an issue with accidental franchise. Well, most commonly, if there's a lease agreement or a sublease agreement that's in place between the licensor and the licensee, and then you have some kind of restrictions in there. If you have percentage rent that are based on sales, that can meet the payment element. Control over the premises, what the premises looks like, where the premises has to be located. Those types of things, which Nick and I covered at various parts, but those are the typical ways you see real estate become involved in an accidental franchise. There's a question here: are there any exemptions, exclusions for nonprofit organizations such as 501c3? That is an interesting one, Nick. I don't know if you have anything on that, but I've never seen that, because typically in these accidental franchise situations, you're looking for someone to grow their business, and 501c3 is not typically looking at that. But Nick, do you have anything on that?
I don't know of any express exemptions that say if you're a 501c3, you're exempt. I would think if you meet the elements, right, it could be a franchise. We could look into that and get back to you, but to my knowledge, there are no there are no, on the nose exemptions for, specifically for 501c3 or other not-for-profit, type entities.
And quickly we'll just cover the terms to avoid in trademark licenses to avoid an accidental franchise. We covered some of these, but just to summarize very quickly, don't want any terms involving the business operations themselves as opposed to the marks. Focus on the marks. Any approval rights other than how the marks are displayed. Any other approvals about how they operate their business. Any other restrictions on their business that don't involve the trademarks. Those are the things you want to avoid in trademark licenses. And okay, we've run out of time. Sorry we didn't get to all the questions, but the ones we didn't get to, we'll get to a response via email. So thank you all for attending, and hope we see you.